Good evening, everyone. We're delighted to have you with us, and this is a moment we've all been waiting for. My name is Nyaay Singh. I'm the Development Coordinator at the Migration and Asylum Project, or MAP, a legal aid center that will be turning 12 in a few days. As a legal aid center, MAP works with legal services institutions to democratize justice to ensure that marginalized and vulnerable communities are able to access quality legal aid. We are therefore deeply honored and privileged to have with us Honorable Justice A.J. Bhambani, who has a long-standing commitment towards legal aid initiatives. Justice Bhambani, a first-generation lawyer, completed his master's in nuclear physics from St. Stephen's College, University of Delhi. It was here, upon receiving Nani Palkhiwala's book, We the People, that his interest in legal studies began. He then read for his LLB degree at the Faculty of Law, completing it in 1992 and joining the bar. He set up his own chambers in 1994. He practiced before the Supreme Court of India, the Delhi High Court and other high courts, and the subordinate courts, conducting matters on a range of issues. He has done substantial legal aid work before various courts, including in the field of juvenile justice and the death penalty. He served as a panel lawyer of the Delhi High Court Legal Services Committee from 2009 to 2014 and was nominated member of the Statutory Committee of the Delhi High Court Legal Services Committee from May 2014 and a member of the Monitoring Committee for Legal Aid Lawyers. He was designated Senior Advocate by the Delhi High Court in February 2014 and appointed Judge of the Delhi High Court in October 2018. I would like to call Ms. Roshni Shankar, Founder and Executive Director of MAP, to give a short welcome address and give Justice Bhambani a token of our appreciation.
Good evening, everybody. My name is Roshni. I'm the Executive Director of MAP. Before we move to the keynote address, I see so many influential figures in the bar and the bench here today, and I'm tempted to talk to you a little bit about MAP, something which I'm very passionate about. Over the last 2 days, we've been talking a lot about access to justice, and many of us in the fraternity talk about the lack of access to justice. And I think the general consensus, something which all of us can agree on, is the fact that for the common citizen in India today, they don't perceive the right to justice as any public service. They don't see it as the right to food or education or health. And that is something MAP is trying to change. Now, a lot of us know that there are problems in the system and justice is not accessible to most people in India. However, I think most of us don't know the scale of this crisis that we're facing. So let me share some data with you to inform you about what kind of crisis we're all facing. Sorry. Closer? Okay, thank you. All right. So I'm going to share some data from our good friends at the India Justice Report. And the recent data says that about 100 crore Indians are eligible for legal aid. Let that number just sink in. There are 140 crore people in India, and 100 crore of them are eligible for legal aid. Now, does this mean that 100 crore of them need legal services? Perhaps not. But what this means is that legal institutions need to be equipped to reach these 100 crores, inform them about their legal rights, and make their services available. Right? If you look at the data from the last 30 years, which is 30 years since the enactment of the Legal Services Authorities Act, legal services institutions have collectively reached 1.5 crores. That's 15% of the overall number of people who are eligible. Within this group, there's another concerning trend, which is that only about 30 lakh or so are women. The reason this is concerning is because the law gives all women and children the right to legal aid, irrespective of their economic status. So you would expect that the overwhelming majority of people who are accessing legal aid are actually women and children. But the data tells us a different story. Now let's look at the resources that are at our disposal to reach these 100 crore people. So the budget this year, which was given by the Ministry of Law and Justice to NALSA, stands at 200 crore. There's been an increment since the last year, but it's only marginal. It sounds like a big amount of money, but when you look at the per capita expenditure on legal aid, it stands at 1 rupee per person. Right? This is amongst the lowest in the world. Then let's look at the number of people we have at our disposal to provide legal aid to these 100 crore people. So we have roughly 50,000 legal aid lawyers, and we have about 45,000 paralegal volunteers. Quite a few of them are here today in the room. And collectively, that's about 1 lakh legal aid actors who are supposed to reach these 100 crore people. This is the gap that we're facing when we talk about access to justice in India. The purpose of Nyaay Sabha was to bring together legal aid actors of diverse profiles. So we were very lucky to have over 200 participants over the last 2 days. The profile of the legal aid actors was paralegal volunteers, lawyers, NGOs, and representatives from the DLSA, SLSA, and NALSA. And we looked at these problems from various lenses. The recent Parliamentary Standing Committee report, which we've been referencing again and again over the last 2 days, talks about multiple barriers in legal aid. And this is what we spoke about, the lack of legal education amongst our citizens, the lack of budgets, the lack of outreach, accountability frameworks, underutilization of budgets and existing resources, and lack of incentive structures. Over the 2 days, with the conversations that we've been having, very organically an action plan emerged. And this is something I've taken the liberty to put together, and you can see that on the screen. So some of the suggestions we've been hearing again and again over the last 2 days have been: the first is the need for an impact assessment, or a social audit, as we call it in the NGO world. The purpose behind an impact assessment is to see how these various schemes which NALSA and SLSA have initiated, how have they been implemented on the ground. This is something MAP has been very committed towards, and because we work with very vulnerable communities, we often look at impact assessment from both a qualitative and a quantitative lens. The second action plan which has been recommended is that of policy reforms. I think many of us agree that schemes like LADC are extremely positive and they're a step in the right direction. But when we go on the ground, we hear about poor implementation. We hear about recruitment policies that are not transparent. We talk about lack of incentive structures. We hear about lack of mentorship and handholding. And these are policy issues that need to be addressed at a systemic level. The third action plan that has been recommended is capacity building. And I think this is something everybody unanimously has spoken about. Our paralegals have highlighted it again and again, is that they need more training. They need more legal training. And it's not just training on the laws. It's training on soft skills, it's on mediation, it's on leadership skills, and several other things. The fourth action plan is that of gender and diversity. And like I said previously, the purpose of legal aid is that it should reach the most vulnerable. Typically, these are women and girls and people belonging to marginalized groups. But when we look at the legal aid network itself, we often don't find diversity within this network. So unless and until we have people from these groups being represented amongst PLVs and legal aid networks, we are not going to be able to reach these groups. And the last action point is that of technology. Yesterday, we had some amazing speakers who told us about the different platforms that exist, or people are trying to create these platforms for use in the legal aid sector. However, I think one of the things they said stuck with me, which is that we don't need to think of AI. I think the minute we talk about technology today, we talk about AI. We don't need AI. We need to start with Google Forms. We need to start with a basic platform like WhatsApp, where people can talk about cases, legal aid cases, in a secure and a confidential way. Like I said, these are action plans which MAP as an organization is extremely committed to, and we hope that after these conversations for 2 days, many of you will join us in this mission. Going back to the impact assessment point, like I said, this is something MAP has been doing for over the last many months. One of the schemes that we've been looking at very closely is the paralegal volunteer scheme. The idea behind this research is that we want to see what is the impact of this scheme, which is now 15 years old. I think now it's the 16th year. How has this scheme translated on the ground? So if you look at the report today, we're very proud to present you the first copy of this report. And the idea behind the report is that we want to inform the broader narratives on legal empowerment, not just in India, but also globally. So I'll just give you a quick overview of the report before we launch it. The report talks about the evolution and the impact of the PLV scheme in India. We look at, like I said, both quantitative and qualitative data. So to put together this report, we have interviewed over 1,200 legal aid actors across 9 states. We are also trying to contextualize India's PLV model within the larger global landscape. So we've looked at the PLV model in Sierra Leone, we've looked at it in Kenya and other jurisdictions which might be comparable. And most importantly, we trace the role of courts in recognizing and empowering these networks. How many judgments have categorically made a reference to paralegal volunteers, and how have they empowered them to do their work better? And lastly, the role of CSOs like MAP, who have been involved in extending the outreach and building capacities of legal services institutions. So like I said, I'm very proud to present a copy of the report today, and I request my research team to please present a copy to Justice Bhambani so that can be officially launched. Thank you. I now request Justice Bhambani to please deliver the keynote address. Thank you.
Ms. Roshni Shankar and her team from the Migration and Asylum Project, members of the SLSAs and other office bearers of the legal aid societies from Delhi, Uttarakhand and Himachal, members of the audience, my young friends, ladies and gentlemen. In the last 2 days, from the sense I get from Ms. Shankar's address, in the last 2 days, you all have most certainly plumbed the depths of legal aid, of the various schemes, of financial outlays, and you must obviously have spoken of the constitutional architecture, the legislative framework, etc. So Article 21, the constitutional promise that you will not be deprived of your right to life or personal liberty except in accordance with law. Article 22, you will have the right to be defended by a legal practitioner of your choice. Then Articles 14 and 39A, equal justice, free legal aid, all of that you would have done. Let me pose a contrarian question to you. Why should anybody get legal aid at all? When you committed the crime, जब आपने murder किया, हमसे पूछ के तो नहीं किया था. It is the state which is prosecuting you. Now you want to be defended by the state or at state expense? What a strange idea. So, who needs legal aid? And let me answer that in a hurry. Forget the litigant. The court needs legal aid. Try deciding a matter. Try sitting in my chair one day and try and decide a matter where it's only the litigants who appear in person. If you don't need psychiatric help by the end of the day, I'll give you a cup of coffee. I'm not for a moment meaning to demean or to diminish the grievances that people have which bring them to court. I'm not suggesting that people don't have the intellectual capacity or level. But let's be clear, our legal system is quite complex, it is arcane, it is abstruse. It is not a system that anyone, just a regular person, a regular citizen can understand. It is meant for that citizen, but it is not really comprehensible to the citizen. As a matter of fact, I would say that ours is the only system where the consumer of that service, of that system, has the least say in the matter. So a litigant walks into court, he has a problem, he's not come there just for a visit, it's not a place of tourist interest. And you will tell him, but you are represented by counsel, please sit down. But he has the problem. So be sure that it is not just the litigant, but it is the court itself that needs legal aid. Otherwise, we will have stories beginning, sir, I woke up in the morning, I was having my first cup of tea, and then the doorbell rang, and as I opened the door, this man was standing with a gun pointed to my head, and then he said this and that, and he robbed me of 1,000 rupees. Now, you're really at that point saying, all right, man, get on with it, get to the point. So, not only does the litigant need legal aid, the court needs legal aid. And how much a litigant needs legal aid has been emphasized and re-emphasized by the courts at all levels since forever. Even a person who was at that time public enemy number one, Ajmal Kasab, the Supreme Court, Justice Aftab Alam at that time, made it very clear that it is the magistrate's duty to ensure that a person gets legal aid. And unless that person specifically declines it, you have to give him legal aid. So legal aid is an opt-out option. It is not something that a person needs to choose to get. It is something that must be served to him until he says no thank you. Now this legal architecture that we have under the Legal Services Authorities Act of 1987, essentially the way it's panned out is after the stage when a person is either arrested or I'm sticking to the criminal side of legal aid, only because I think that is also the more sensitive side. So it kicks in only when a person gets arrested. Now that itself is a fallacy. Way back in 1983 in Sheila Burse's case, the Supreme Court says that the moment you arrest a person, you have to inform the legal aid committee and they must provide him legal aid, not when you produce him in court. That, however, we know hardly ever happens. So the whole architecture of legal aid needs to be extrapolated backwards so that it begins when the need for legal aid arises, which is at the beginning of the problem, not much later into the problem. Hence, paralegal volunteers. Now I'll dilate on that in just a moment, but on the bench, I've been seized of a matter in a division bench, where this PLV scheme, which was started by the Delhi government, then initially only for missing children, then expanded by the Supreme Court to all crimes relating to children, has had a huge pushback from the police establishment. And the pushback was to the point that where should we allow the legal volunteer, the PLV, to sit in a police station? That became a matter of debate and discussion. Because as we know, police work is sensitive, police wants privacy. So they would have the legal volunteer sit in some corner, obscure corner of the police station so that somebody is brought in, the person doesn't see the PLV doesn't see the person. So no problem. Now, of course, you all have a deeper insight into the ground realities. You have worked in communities. You've manned legal aid institutions. Let me just share with you my perspective and my insights into the legal aid system as it actually works, as a brass tacks issue, both as a lawyer and now as a judge. See, the points of concern of the legal aid system now, Ms. Shankar spoke of the abysmally low outlays, 1 rupee, to a person who probably deserves legal aid, to the rest of the infrastructural problems and all which you must have debated. But even as things stand, even if there is a functional legal aid system, and I'm proud to say at least in Delhi, there is one, but even if there is such a system, what are the essential concerns that we face on a day-to-day basis to make that efficacious, to make it effective, so that it doesn't just remain as a statutory requirement or provision, so that it becomes actual legal aid in the hands of a litigant. Now, first and foremost, I think there is need for better appreciation and acceptance of the legal aid architecture. So as I said, the police establishment and the prosecutorial establishment are not very welcoming of legal aid. It makes their job tougher. No policeman wants anybody to know, anybody from the outside to know what he does in a police station. So when you plant a PLV in a police station, there is a pushback. He's an unwelcome intruder. That has to change. The police establishment and the other state machineries need to understand that they must function within the framework of the law. The law is not one-sided, at least that's not the way it's conceived of, and therefore they will have to tolerate and suffer PLVs and other legal aid persons. The other aspect is there is also need for better appreciation of the legal aid system by the litigant themselves. See, whether it's in our culture, whether it's because of the numbers we have in our country, nobody believes that anything can come for free. And even otherwise, I don't think it's a good idea to have a freebies culture. But that being said, when it comes to lawyers, and especially lawyers who are coming for free, there is mistrust. So there is a lack of trust to say that how can any lawyer ever work for free? I will narrate to you my personal experience. I was appearing in a legal aid matter in the High Court, and the man was in jail. His brother was coming, and he used to be in touch with me. He tells me, "Sir, 1 minute." We were waiting in the lobby, waiting for the matter to reach. He says, "Sir, 1 minute." So I said, "Boliye." "Nahi sir, wahan idhar aa jaye." He took me to the stairwell, pulled out a wad of notes, and said, "Sir, ye aapke liye." So I said, "Look, I'm getting paid, all right? It's free for you, but I'm getting paid, so it's all right. I mean, I'm fine. I don't." He could not believe that anybody would do an honest day's job unless paid. My law researchers are sitting here. Let me just digress. We often have fun at the expense of our own brethren. So, with due respect, I'm still part of the legal tribe. This lawyer dies. He goes to heaven. Lawyer goes to heaven. He's greeted by Saint Peter. He says, "Son, you were 125 years old?" He says, "No, that's not true." He says, "But if we look at your billing hours, you must have been 125 years old." So, nobody believes that lawyers can come free. So the system has to be explained to them, that the lawyer is not free, it's only free to you. I have also noticed that legal aid beneficiaries prefer to engage private counsel at crucial stages of their case. So we'll have a case, an appeal, a criminal appeal, going before the court, represented by a legal aid lawyer. Then somebody will file an application, one of the accused will file an application for release on interim bail or some other interim relief or something of the sort. And a private counsel will stand up for him. So one often questions that you were represented by legal aid. Can you afford a lawyer or can't you afford a lawyer? Tell us clearly. Because again, they believe that the quality of a legal aid lawyer will never be the same as one who charges. So I have said in an article which it began as an address like this, and then it was published in Sage Publications, and recently the Supreme Court has used the same words. Legal aid for the poor should not be poor legal aid. So this whole pipe dream of Article 22, everyone is entitled to be defended by a lawyer of his choice. Are we? We don't even give the litigant a choice. A lawyer is assigned to you, especially in the legal aid system. Take it or leave it. So what do we do about it? So what we must do is to improve the quality of the lawyer who is available on the legal aid panel. So the whole concept that a legal aid lawyer will never be of the same metal, of the same caliber, has to be disabused. And we have to make a reality of the fact maybe a person can't be given a choice of lawyers, also because he will have no idea who to pick. But at least the quality of lawyers who are enrolling in the legal aid panel has to be much, much better. How do we do that? By better selection. So it has to be a rigorous selection process. In Delhi, we have a very rigorous selection process. We get hundreds of applications. Those are sifted. Judgments are called for. Interviews are conducted. And then a person gets onto the legal aid panel. And we have lots of takers. That brings me to the other aspect. Not just the lawyer, not only should the lawyer be of a certain caliber, he should have the correct orientation. He must come into legal aid for the right reasons. Now, in Delhi, there have been instances, I think, which are now diminishing, where lawyers would join the legal aid panel because they didn't have any other work, where lawyers would join the panel because it was a requirement for getting seniority. Now, that may not be the best orientation for a legal aid lawyer. There has to be a person who is dedicated, who's professional, who's committed to the cause. And I think there is good reason to be committed to the cause. Because the kind of matters that you get to do today, things have changed. A lot of the top-notch matters that get reported in which law gets laid down and all relate to big guns. But if you go back when the law was actually being laid down in our country, the kind of litigants were very different. So, if you see Justice Krishna Iyer's judgments, Moti Ram versus State, Ram Singh versus so-and-so. So, those were matters which were deep as far as and very weighty as far as the law was concerned. So, if a person is a serious professional with an interest in law, in the scholarship of law, there should be no reason why that person finds the legal aid panel underclass or not chic. The other point that is needed to improve the level of legal aid is that there has to be very rigorous professional involvement. Now, what do I mean by that? When we get a private brief, the number of hours that is spent in reading the papers, in debriefing the clients, in having client conferences, in researching the law, that same level of thorough and rigorous professional involvement is necessary. This has to be taught and it has to be monitored. Now, that is an aspect which is missing even in Delhi. I have no experience of the other states, but that is an aspect of reviewing whether a person has been rigorously involved with his cases. I might also point out that it's a lot more challenging to advise a legal aid client. Unlike an urbane, well-spoken, well-educated sometimes over clever client who will come in and teach you what to say, what not to say. Legal aid clients are very difficult to manage. I'll give you an example. My friend Anant Asthana is sitting at the back. We did a matter together many, many years ago. It was an horrific incident that happened in Delhi. One of the accused was a CCL. We had no access to him. Mr. Asthana said that his mother lives in a remote village in UP. I said, look, we need to talk to her. What happened? How it happened? Did her boy have a problem, a psychological issue? We just need an interaction with the client. We don't know anything about it. He got onto a bus, drove all the way to the village in UP, put the mother on the bus, brought her to my office. She came. She sat on my chair in the conference room with folded legs. माता जी चाय पिएंगे? कुछ सुबह से कुछ खाया? कुछ नहीं खाया. चाय पिएंगे? नहीं, ठीक है. We have to make her comfortable. Before she talks to us, she's in an alien environment. She's faced by these people who seem very English spoken. There's a disconnect. So, to debrief a client like that is not easy. And unless you do that, you will not have done justice to your brief. Then, of course, there is the basic issue of lack of care. A lot of legal aid lawyers just simply do not care. And they have got onto the panel, as I said, for some ulterior reason, ulterior motive. They don't have the time for all this. If it comes to attending to a private brief versus a legal aid brief, they will first run to the court where the private brief is pending or is called out. And that, I think, is completely destructive of the ethos and the whole philosophy of the legal aid system. So while we may talk of budgetary restrictions, numbers, statistics, 100 crore beneficiaries, 200 crores annual budget, etc. That's all important. Not for a moment am I suggesting that that is not. But the heart has to be in the right place, and that's a lot more difficult to achieve. Another concern, an area of concern, is access to clients. Now, as distinct from what I just mentioned, which is communication with the client. A legal aid lawyer normally gets very limited access to the client. In Delhi, we have a system of jail visiting advocates and the counsel who arguing lawyers. So the jail visiting advocate has access. He goes, visits jail, he speaks to the client. There are systems, there are facilities. But then there is a disconnect between what he saw, heard, understood, and the arguing counsel who actually appears in court for that same litigant. But this is Delhi. And I don't know what how access is arranged in other states, but this rigorous involvement with a legal aid brief has to be a two-way street. So unless you are given comfortable private access to your client, it's very difficult to defend a client like that. I'll give you an example. And this is not to do with legal aid. A well-heeled businessman got into very serious trouble in Baroda many years ago. The accusation was that he was party to bribing a magistrate. He was being held in judicial custody in Baroda. I was engaged in the matter. Beginning of my career, I went there. Lawyer has come from Delhi, wants to meet him. All right, bring him in. I was made to sit in what appeared to be the superintendent's room or some deputy superintendent's room. There was a table. I was made to sit on a chair. There was another chair vacant next door. This man was walked in. He was made to sit on the floor. Now he was, as I said, a well-heeled businessman. There's a chair vacant there. but you sit there. You please, your lawyer will sit on the chair, you will sit on the floor and talk to him. In the earshot of whoever was around in that office. Now, clearly, there is no way that that would amount to an effective legal conference. How is he supposed to tell me anything that he wants to? So, privacy is important. Access is important. It is important to not treat an under trial as if he was beneath everyone else. So these are just those finer things which I'm narrating only to say that yes, of course we need budgets, we need facilities, we need to study the system, but we also need to work the system. And lastly, I think, and this is a very important point and I'm not sure it's been addressed at all. I'll be happy to be corrected on this. Collection of defense evidence, especially in the legal aid architecture. Now, every prosecuting agency has its own officers, its investigating IOs, etc. How does an accused person collect defense evidence? Now, theoretically, an IO is supposed to collect both inculpatory and exculpatory evidence and place everything fairly. And in those more sophisticated matters, like matters under the PMLA, etc., you have relied upon documents not relied upon, whether an accused is entitled to copies of both or one, all matter of judicial decisions and all of that. But how does a person defend himself if he has no means of collecting evidence in his defense, especially when he's in custody? How does the legal aid system help such a person? Given the backdrop that the person may be from a strata of society where he's not educated, he's not lettered, he's not communicative, he may have been picked up from some other state and brought into some other state, so there's a language barrier. Now, for that person to say to his lawyer that, you know, when they entered my house, they were carrying such and such thing, which they left in my house, but that's not been collected by the IO. Or maybe he collected it and he deemed it inappropriate to produce it. See, IOs have this, they have a literary ability. Sometimes I tell them in open court that you've produced a charge sheet which discloses great literary talent, but what about your investigative talent? What is the material you brought to support this whole lovely storyline that you've put down in front of me? So it's just the way they are trained. So as I said, appreciation of the legal aid system by the IO. He should not, I don't know whether the police establishments gets brownie points, or do they get increments, or do they get promotions for just cracking cases as they go around cracking skulls? We don't know. But so this ability of the legal aid lawyer gets seriously diminished because he has no way of going around collecting evidence or doing anything of the sort. Now, if it were a private client, they have their own resources. They may provide you more resources as a lawyer, but now to expect at a legal aid brief, the lawyer should also go. I mean, there are, as I said, like Mr. Asthana here, who travels all the way to get whatever needs to come to Delhi. But that's not the way. It's not a realistic expectation to expect a legal aid lawyer to also now become an investigator. So even in this LADC system which we are now implementing, it's already started in Delhi. Where is the investigative wing for the defense? And though these may all sound matters which are restricted to criminal law, I say for one, that is the branch of law which needs the most urgent attention, resources, and thought. But they would also affect any other legal aid case. So these, friends, I would say, are my thoughts, my inputs which I would want to share with you. And I'm sure you've had a grueling 2 days of sessions, so I don't want to overstretch my welcome here. Thank you so much for inviting me, and thank you.
Thank you so much, sir. I know we absolutely enjoyed what you had to say, for your unique insights, both from the perspective of a lawyer and a judge, which re-emphasized the criticality of legal aid providers in the legal aid architecture, but also, particularly PLVs, and shining a light on the more opaque aspects of the criminal justice system. I would also like to take this opportunity to thank all of you here, those who stayed with us over this 2-day journey. The consultation looked to shift the lens towards duty bearers within the legal aid system to understand how we could meaningfully move the needle towards ensuring that justice reaches those that need it the most. So thank you once again for being here, and we hope to take this collaborative conversation forward with all of you. Thank you.